Learn Investments versus Rebecca Rudisil. We were here last on October 3rd. We adjourned the matter for 17 days. At that time, it was alleged that rent was $5,320 in arrears, $325 in late fees, and $172.17 for a total of $5,827.17. Ms. Rognus, are the numbers the same?
Yes, sir, Your Honor.
No payment made?
I believe they've got some paperwork from one of the agencies, but no payments.
Ms. Rudisil, that's one of the reasons why we adjourned it. You work with Neighborhoods, Inc. Have you got anything from them?
They're waiting on to send something with the rent on it. I stopped there yesterday again, and they were still waiting on the thing from Vicky.
Well, I'm about to give you the judgment with these numbers on it. I find through October. Of course, on November 1st, another month's rent is going to be due. We got $5,320. I don't know if this is what they're waiting for, but you'll have a judgment. Late fee is $325. And costs are $172.17 for a total of $5,827.17. You have 10 days in theory to pay that. 10 days from today would be October 30th. We'll still be in the month of October. Partial payment will not prevent a writ of eviction. So if they give you $4,000, you would still owe the balance, $1,827, to get completely caught up. And it's only paying the full payment that will prevent the writ of eviction. Now, they can agree to work with you. Mrs. Lerner, we started a little early. The client was here and Andy was ready to go, but the numbers are the same as they were last time. Shows $5,827.17 by October 30th. She has been in contact with Neighborhoods, Inc., and I think they're waiting for this judgment to show the numbers, although they don't actually need one, but they often believe that they do. You also have until October 30th to appeal that. So it's important you do two things: stay in contact with Neighborhoods, Inc. and stay in contact with your landlord. They can agree to work with you if they wish to. This arrearage is pretty big. By November, it's going to be over $6,000. But if they're going to give you some assistance, great. If not, you may want to go to Plan B and figure out where you're going to move to. Do you have any questions?
Yeah, I just wanted to find out. When I first moved in here, I was supposed to be credited 1 month of rent for cleaning the apartment when I moved in, because it wasn't cleaned and I had to paint it. And I just wondered if they were going to knock that off.
That's the first I heard of it. That didn't come up last time.
I wrote
Ms.
her.
Learn, do you have any?
I've wrote her twice and I haven't heard from her.
It's not on the lease.
It's wrote on the bottom of mine where they wrote paint and cleaning in the apartment.
I
What
guess,
page?
Your Honor, that's an issue regarding security deposits afterwards.
All right. Tenant will clean and paint apartment. It doesn't say there's a credit. All right, well, hopefully you'll get the assistance. If it becomes an issue, we'll discuss it further, certainly before writ issues.
Okay.
All right. Miss Learn, do you know anything about that?
Yeah, we did talk to her about it, but we don't have anything written down with regards to how much. And from my recollection, it was not cleaned entirely. However, we can always work with her on that. But what I would like to say though, is that she is not living there. Her son is. And he is not on the lease. And she had talked to us at the beginning about maybe him moving in, but it was with her. None of our tenants have seen her there. Nobody knows that she's been there. She supposedly has been, and this is hearsay, one of the tenants stated that she lives with her husband and granddaughter in a house outside of town. So if she's going to the neighborhood for help, that's in her name, doesn't have anything to do with the rent that is owed to us.
Well, this is not filed as a termination of tenancy action. It's filed as a non-payment of rent. Miss Rudisill, they're not to give you rent to pay money to pay your son's rent if he's not on the lease. So there may be a issue of
No.
fraud. If
I'm living
so-
here. Just on the weekends, during the week, I go pick up my granddaughter from school and I bring her home. She rides the bus home to my husband's house.
All right, well, I don't know. We'll see. There's no evidence. Nobody's under oath. So are you at the Elm Street apartment right now?
I'm here right now.
All
I've
right,
been here all day, all night. I was here.
all right, that's the number, 5827. We're gonna send it there. All right. Let's see what happens. If you wish to terminate the tenancy because you've got an unoccupied tenant in there, you can do that. So there's one thing, you're living there sometimes, sometimes not. Your son is living there and he's not on the lease. So that could be a problem. Right now, this is just a non-payment of rent case. All right, that's the number,
Okay.
5,827.17. All right, do you have any other questions, Ms. Rudisill?
No,
All right. I'll send you a copy of that in the mail today. Thank you.
thank you.
Thank you, Your Honor.
Thank you.
Do you know where Miss Campos is?
Oh, she's not feeling good today. She had a stroke not too long ago, so she's resting in bed.
All right.
I'm actually under the weather myself.
Well, it looks like you made it to work.
Yeah, can't afford to lose making money, so trying to catch
Yeah.
everything up as soon as possible.
Yeah, and in your honor, I think they're working on getting some assistance, and so we're gonna allow them some time to do that. We just wanted to request like a 3-week adjournment if we could.
All right. Well, let me go through the rights. The law is required that I do that. In fact, I got a note from one of my colleagues who's on the Judicial Tenure Commission, and they've been receiving complaints about judges who aren't advising clients of their rights in these landlord-tenant cases. It is tedious, but the law requires that we do it. And I try to do it every single time, so I'm not one of the ones they're complaining about, but Mr. Gibson, you're a tenant and you're in a landlord-tenant proceeding. And it's a non-payment of rent, and this looks like it may be lot only, which is something we're going to discuss in a minute. You have a right to hire a lawyer. If you cannot pay for an attorney, the court would give you information about how to retain one. We sent you the information regarding legal aid. They're usually here with us on the feed. She's not here today. She must have another obligation. But the number of legal aid is on the pleadings. You have a right to have the case heard in the county where the property is located, and that's here. That's never really been an issue here. You have a right to demand a jury trial. If you want a jury trial, you must tell the court this first appearance or make the demand in writing within 5 days of the court explaining that right to you using the jury demand form. You have to pay a $50 fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal help for homeless veterans if you're a veteran. You should have received that information with the packet we sent you with the summons. You do not need a judgment against you to receive help from places listed above, despite what one of our earlier defendants told us. A copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, we can pursue that. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case they would file what's called a conditional order of dismissal. This looks to me like lot only, which is a matter of some controversy. Some counties don't allow lot only. The law is not clear. I've seen briefs for and against it. I've seen opinions both for and against it, but this is $395 per month. Ms. Villa, your manager, is also present. Mr. Sickle, is just lot rent?
That is correct, Your Honor.
One of the reasons I do it, it allows the defendants to perhaps get some emergency financial assistance and redeem the tenancy. However, I'm not sure that they fund lot rent only. I guess we'll find out. Mr. Gibson, which agency are you working with?
There's a few we're working with right now. The last place that's helping us with the last remaining balance that we owe, I had a mix up with some pay stubs, so I had to resubmit them today. So I'm hoping today after court sometime or tomorrow evening that will be paid and everything will be just dropped and done with.
All right, well, how much is the arrearage, Mr. Sickle?
It's $990.62 plus $60 in late fees. So the total is $1,050.62 plus court costs.
See, that's not what it's showing on.
Sir, I ask you to remove your hat. We're in a court proceeding.
Sorry.
Your hair looks great. What is the court cost?
Court costs include $136 filing fee, $75 attorney fee, and process server fees in the amount of $112.40. Total there is $323.40.
Equals $1,374.02 is what I get.
That is what I show as well, Your Honor.
That's through October. Mr. Gibson, by the time I set this, it's going to be November, so another month's rent is going to be due. But if they ask for 3 weeks, that takes us to November 10th. When you're, usually it's a 7-day adjournment.
Yeah,
when
I think
there's assistance, we can go 14, and if they request, we can go farther.
the last go round, Your Honor, he had some assistance from the Crossroads Missionary Church. So I think there might be some non-government agencies that are at play here.
Okay. That's a nice church, with a nice congregation. They used to print a newspaper. I'm gonna set this for 2:10 on November 10th.
2:10 PM on November 10th.
Yes. Does that work for you?
That works for
Sir?
us, John.
All right, now let me tell you some things you need to know. Partial payment will not prevent the writ of eviction. You have to pay the entire amount. And it looks like you're in pretty good shape. It's not too far behind, but rent's $395. So the amount right now is $1,374.02. Might as well add another $395.
That should all be taken care of either today or tomorrow, and then,
All right. Well, if everything is paid off, nobody even needs to appear.
well, yeah, that's the game plan, because I don't want to fork money out of pocket again for court costs if I have to come back to court. So I'm trying to get it all paid today and tomorrow. And then, but on my app, it says that I owe 14 something, not 13 something. So I'm confused on what I actually owe, because
$990, 62, $60 in late fees, which I think is 2 months. 1050, $1,050.62, 323.40 in court costs. That's the filing fee, the service fee, and the attorney fee. So
We'll
the
sort
total
out the
is
exact number.
$1,374.02. And November 1st, another $395 is due. All right, do you have any other questions?
no, sir.
All right, you're good to go.
Thank you, Your Honor.
29GC. It's entitled Credit Acceptance versus Amanda Warner and Deontay Johnson. Amanda Warner is here. And attorney Bradley Johnson is here. This is defendant's motion objecting to garnishment. Defendant works at ACCUSES, which I think is a division of American Axle. She filed an objection to garnishment. And included her argument. Plaintiff filed an objection to garnishment, alleging that the current balance is $7,769. Trying to find her motion. She wrote a letter dated October 1st. I'll read it. Your Honor, I'm writing respectfully to review of the wage garnishment currently in place for the above referenced case. I believe the debt has already been satisfied. I kindly ask the court to review the records to confirm whether the obligation has been fulfilled. And if so, in order to stop further garnishment. I have attempted to directly communicate with the collector to obtain receipt of payments, confirm the balance owed. I've been directed back to the court. According to my credit report, this debt has been satisfied in full. I can provide documentation to show all payments made toward this obligation, which I believe has been satisfied. If a determination that a balance remains, I respectfully request a reduction in the garnishment amount. I'm the primary financial supporter of my children and family. Current level of garnishment creates a significant financial hardship. A reduced amount would allow me to meet my obligations to the courts while ensuring that I can provide for my defendants' basic needs. I appreciate the court's time and consideration of my request. Thank you in reviewing my circumstances. Plaintiff then filed an answer with an accounting. What often happens is the defendants don't take into account the fact that there's 13% interest on this debt. It's a plaintiff's contention that the current balance is $7,769, which is a long way from having it paid off. Mr. Johnson, do you wish to speak to that?
Yes, Your Honor, I know that the defendant improper, filed the objection and kind of put in her letter also the some about an installment payment order, maybe reducing the garnishment. I'm happy to have that discussion with her about reducing the garnishment to a level, because we are getting very good money, and I know that's gotta be a burden, so I would like to have that
Yes.
conversation with her.
All right, a garnishment is a big whack on your wages and doesn't leave you enough money to feed your kids. So he's willing to speak with you in a breakout room, Ms. Warner, about perhaps setting up sort of installment payments. Are you agreeable with that?
Yes,
Your letter was very well written,
thank you.
succinct and clear. It wasn't exactly an emotion form, but we certainly understand what it was about. So I'm going to put you in a breakout room with Attorney Johnson, and we'll address our next matter. So when the button says join, you join, okay? All right, we had some parties in the breakout room and they're back. That would be Bradley Johnson and Amanda Warner. How do we do?
We were able to reach an agreement, so I will let him explain that.
Thank you. Mr. Johnson?
Thank you, Your Honor. I spoke with Ms. Warner in the breakout room. We agreed to a installment payment order that will stop the garnishment. Ms. Warner agrees to pay the sum of $470 a month, beginning January 1st of next year, and then $470 on the first of each month thereafter. So long as she makes the payments as agreed, the garnishment will remain suspended until the judgment is satisfied. However, if Ms. Warner defaults and we file the appropriate motion and she does not object, or then we can try and get the garnishment back. So I don't know how the
All
court
right.
wants to handle this. If the court wants me to do a 7-day with the order, or
Yes, I would request.
okay. I will get that proposed
I'll explain
order.
that, Ms. Warner.
Yeah, that's kind of why there's a gap between today and January 1st. Also with the holiday, but I know that it takes time for the employer to get this order.
All right. Now, this will forestall any further wage garnishment. It would theoretically allow for a tax garnishment, but $470 a month is a pretty substantial payment. But the debt is about $7,700. Your bugaboo is the 13% interest. He's going to submit an order that says they're going to forestall garnishment of wages if you pay $470 per month starting January 1st of 2026 and the first of each month thereafter. And he's going to send that to me, and he's going to send it to you. If you don't do anything, it will simply enter after 7 days. If there's a mistake in it, like it says it's going to pay $670 instead of $470, hopefully we would catch that ourselves, but you'll have 7 days to object. Otherwise, the order will enter. So you can have a little bit of a break for November, December, January 1st. You can start the payment. Perhaps you could even set up a direct withdrawal from your employer, and that would work also. All right,
That's
Ms.
what I
Warner, do you
plan
have
to
any?
do. Thank you.
All right, let me make a note of that. Do you have any questions?
No.
All right, now their information is on the file. So if you want to call and discuss it further, you can do that.
Okay.
I think that's Miss Pfeiffer's car. I'll mute her for now. She's in a noisy spot. All right, you guys are both good to go.
Thank
Okay.
you.
All right, thank you, Your Honor.
Next is Samantha Wells, ACCUSES is her name currently. Midland Credit versus Samantha ACCUSES. File number is 25763GC. It's a claim for $11,000, 303.79.
What?
A default judgment entered in this matter. Flip back to it. It was entered on August 29th in the amount of $11,516.59. The defendant was served with a lawsuit, didn't file an answer. She was served with a lawsuit on May 17th. It was filed on June 9th. The default judgment was entered on August 29th, quite a ways later. And no answer had been filed. The defendant filed a motion to set aside the default, alleging that she had filed some things in the circuit court, but they declined her filing. The things that she did file were filed on September 15th, which were 5 days after that entered on the 29th of August. Plaintiff filed a brief opposing your motion to set aside the default, arguing that you didn't meet the standard as for the court rule to set aside a default, that you need to establish a meritorious defense, in fact, an affidavit of meritorious defense, and a reason for not responding to the lawsuit.
I have this Zoom running. Do you want me to put those ladies in there or just leave them where they are?
They're fine for now.
Okay.
So it's your motion, Miss Maciosi. What else would you like me to know?
Your Honor, I have been in contact with Midland Credit Management multiple times. None of this shows on any of my credit reports. It shows as it's been settled, like it's taken care of. So I have wrote them multiple times asking for the purchase agreement. They have wrote me back and provided me with the bill of sale, everything but the purchase agreement. They have never provided me with anything of a contractual agreement that has my signature on it, that has me paying obligation or has me obligated to pay this when it shows taken care of on my credit report. They fifth
All right,
or
let me stop.
okay.
Let me stop you for a minute. Then why didn't you tell me that in a timely manner instead of now?
So that may go. Somebody's got me in a closed loop.
I just set this up because they said they were having trouble with it. And
letting them know that they needed to provide me with this purchase agreement. I asked them all of that again. And
All right, we
nothing.
didn't file anything with the court. No, I'm not sure
where I'm getting rebound.
Let
Let me
mute
mute
you and see if it's you.
I think we fixed it. All right, this is a motion to set aside the default. So right now you're alleging some sort of meritorious defense. Why didn't you file that with the court? You got served in May and the default didn't enter until September and we never got any filing from you.
I thought that I did file with the court. I believe it was in June. Like June 6th or something, June 3rd. I went to the courthouse and thought that I had filed. They took my paperwork. They looked it over. They told me that I needed to send my paperwork to the lawyers at Midland Credit Management. So that's what I did.
Did you file it up on the second floor?
Yes.
All right, so you filed it in the wrong court. I'm not sure what they did with it.
And I thought that I put in my letter that I explained that when I called back, because I had received the judgment of like the garnishments or whatever, I was really confused because I had written you and them a letter asking for all this stuff because I'm not understanding if it's saying settled why I need to pay Midland Credit Management.
Well, just because it doesn't show up on your credit record doesn't mean you don't owe the money. They write the stuff off, whoever the original creditor was, and then Midland Credit Management bought the debt. So it might not show up on your credit from the original creditor.
It doesn't show up as anything. It doesn't show up anywhere.
All right, well, that doesn't mean that it isn't owed.
And then Fifth Third has an arbitration agreement, so I'm not understanding why a lawyer's coming after me when it's not legally their responsibility when Fifth Third has arbitration agreement.
Well, none of this did you plead. I don't have a scrap of paper other than these letters that you wrote me after the fact.
I thought that I had filed with the court. That's why there was nothing until I received something saying my wages were going to be garnished. I hadn't heard anything back.
Yeah, that wakes everybody up. You filed the only thing you filed here was on September 15th.
Like I wasn't charged any money when I went there. They took my paperwork, they looked it over, and they said that I needed to send it to the lawyers at Midland Credit Management.
All right, did you do that?
Yes, I did.
All right, Mr. Hill, you got any insight here?
Yes, sir, I do. Yeah, I got on the phone with Midland Credit before this hearing here today to find out the history behind the case. Okay. It appears as if Samantha Wells, now Samantha Maciosi, may have had a confusion of where to file the documents. She wrote a letter to Midland saying, I don't recognize your authority. Basically, this is illegal. Midland deemed it was not an answer to the case at all. Okay, but it was just, it's illegal and unwarranted, and you don't have my signature. This lawsuit stems from a credit card that was opened up in November 8th, 2018. Remained open for a while, payments were made, charges were made, but eventually it went into default. Under the laws, the banks can't keep charging you interest forever and penalties forever. There comes a time when they have to charge it off. They charge it off for $11,303.79. That was done back in May 31 of 21. It was sold to Midland in the ordinary course of business. That's all Midland does, is purchase these credit card agreements. They do not require the permission or the signature or the approval in any way of a defaulted creditor or debtor. Okay, under the law, this is not a breach of contract. This is a lawsuit based on an account stated. So many people say, well, I don't know who Midland is. Well, of course they don't know who Midland is. They've never done business. Midland files a lawsuit. They typically send out communications saying we bought the account. I don't know if that was done in this case, but a lawsuit was filed. There's no real meritorious defense to this. It's not saying, hey, I never had this credit card. I didn't make these charges, or it's a fraud or anything like that. It's basically saying you don't have the right to do it. It's unwarranted. It's illegal. That's not a meritorious defense.
Now, they don't need to show you a signed agreement for the credit card use. In this day and age, there's rarely a signed ink document regarding credit card. People sign up online. You become indebted when you use the credit card, make charges, make payments on it, make charges, make payments on it. And they don't need a signature for that. It's an account stated. You made charges, you made payments, you stopped paying. Eventually they charged the debt off in 2021.
So Your Honor, my
Um,
debt was sold illegally to somebody. That's not, I'm not understanding that. So they
why
don't
do you
have
believe
to-
it was sold? Why do you believe it was sold illegally?
Because what gives the Midland Credit Management the legal right to take over my debt with a contract I had with Fifth Third? Under the Fair Credit Reporting Act, that none of that is legal.
Yes, it is. It happens almost every day. There are large companies that buy debt from these credit card companies, from Target, from Home Depot, from
Yeah.
Capital One.
And like I
You
said,
read something on the internet which isn't correct,
well,
or somebody told you.
Arbitration
You haven't cited any authority to say other than this isn't legal. It is legal. These companies buy large blocks of debt and then they collect on the debt. They have a bill of sale showing that they purchased the debt. It was legal. And they don't need to give you a signed credit card agreement.
what about the arbitration agreement?
Say that again.
What about the arbitration agreement that Fifth Third has, where they're not even supposed to take me to court? The arbitration agreement says that we're supposed to settle it within the company. It went straight.
Well, A, they don't have the debt anymore. Midland Credit does. B, you haven't cited any authority. You're telling me something orally about a complicated legal clause in a 39 paragraph document. So no, they don't have to take you to arbitration. You can request arbitration, but apparently you didn't. And I don't know what it says. You haven't cited it to me other than just your recollection of what it says.
I'm not sure.
So
No.
in order to set aside the default, you have to show good cause for not answering the claim.
I thought I answered. I went to the courthouse.
Well, you didn't. You didn't file it in the right court, and I don't know what they did with it, but they should have even accepted it. There's a form which is supposed to show as an answer, which has got the court heading and the caption and the case number.
I did
If
fill that
whatever you
out, and I
filed
sent
had
that to the lawyer and the court. I filled that out. That's what they got.
All right, and what he said was they didn't accept that as an answer. Your response was, you don't have the legal right to file this. And their contention is that they do. So you're stuck with this. The court finds that the motion to set aside the default is denied. The good cause and meritorious defense were not established. I don't have to like the current state of collection law. People buy debt and then they collect on somebody else's debt. But that's what the law says they're entitled to do. So the motion is denied. The judgment stands.
So what is my payment? Because I have 4 kids that I can't afford my whole check to be taken.
Well, all right. Have they started garnishment?
Nope, not yet.
All right. I would suggest what you do is you file a motion for installment payments.
I don't even know how to do that. I'll probably do it at the wrong courthouse. So how do I do that?
Well, I'm right here in Centerville. We're on the first floor in the district court. The clerks will be very helpful to you.
Well, they weren't
There's
last time. So.
Well, they weren't my clerks.
So
if you come to the district court and ask for the form to file a monthly installment payment, I can forestall a garnishment.
Okay.
They haven't started the garnishment, but they're probably are going to. So you need to preemptively come in here. Let me repeat it. It's called a motion for installment payments. And you could file that and then we'll try to set up a payment. All right, you're good to go. Thank you.
Thank you.